The term assault weapon sits at the very center of America's ongoing and often heated gun debate. It's a phrase that sparks strong emotions and fierce arguments on both sides of the issue. But what does it actually mean? The answer is more complicated than it might seem. For gun control advocates, assault weapon typically refers to semi-automatic rifles like the AR-15, firearms that can fire one bullet per trigger pull, but are designed for rapid shooting and often accept high-capacity magazines. These rifles have become infamous in recent years, frequently appearing in headlines after tragic mass shootings. Advocates argue that their military-style appearance and ability to fire many rounds quickly make them especially dangerous in civilian hands. Supporters of stricter gun laws say these weapons are not necessary for hunting, sport shooting, or self-defense, and that their primary purpose is to inflict maximum harm in a short period of time. They believe restricting access to such firearms could help prevent future tragedies and save lives. On the other hand, gun rights supporters argue that the term assault weapon is vague and misleading. They point out that these rifles operate just like many other legal firearms, firing only one round per trigger pull, not fully automatic like military machine guns. In their view, the focus on cosmetic features such as pistol grips or adjustable stocks unfairly targets law-abiding gun owners. Many believe that proposed bans are based more on how these guns look than how they function, and that such laws threaten the rights of millions of responsible Americans who use these firearms for sport, recreation, and personal protection. They argue that focusing on cosmetic features does little to address the root causes of gun violence. This fundamental disagreement over both the definition and the function of so-called assault weapons continues to fuel legal and legislative battles across the country. Lawmakers, courts, and citizens remain deeply divided, with each side convinced that their interpretation is the one that best protects public safety and constitutional rights. Now, the Supreme Court is being asked to weigh in. Are these controversial firearms protected under the Second Amendment, or can they be banned in the name of public safety? The answer could reshape America's gun laws for years to come. The Supreme Court stands as the ultimate authority on interpreting the Constitution, shaping the rights and freedoms of Americans for generations. Its decisions not only resolve legal disputes, but also set precedents that ripple through society, influencing how laws are written, enforced, and understood. In recent years, the court's role in defining the scope and meaning of the Second Amendment has become increasingly significant, as debates over gun rights and regulations have intensified across the nation. A landmark moment came in 2008 when the Supreme Court decided District of Columbia versus Heller. This historic ruling established for the first time that the Second Amendment protects an individual's right to possess firearms for self-defense within the home, fundamentally changing the legal landscape. However, the Heller decision left many important questions unanswered, such as which types of weapons and regulations are permissible under the Constitution. The court made it clear that the right to bear arms is not absolute or unlimited, and specifically referenced the idea that dangerous and unusual weapons could be subject to regulation. But the justices did not define exactly what qualifies as dangerous and unusual, leaving lower courts to interpret this vague standard. For more than a decade after Heller, lower courts across the country developed their own tests and standards for evaluating gun laws, resulting in a patchwork of conflicting rulings and legal uncertainty from state to state. In 2022, the Supreme Court once again reshaped the legal landscape with its decision in New York State Rifle and Pistol Association versus Bruin, a case that challenged New York's strict limits on carrying firearms in public. The court ruled that gun laws must now be consistent with the nation's historical tradition of firearm regulation, requiring judges to look back to the founding era for guidance. This new historical tradition test has sparked widespread confusion among judges, lawyers, and lawmakers, and has triggered a wave of new legal challenges to gun regulations nationwide, including high-profile cases over assault weapon bans and magazine limits. Now every court in America must look to history, examining laws from centuries past, to decide whether modern gun regulations, like assault weapon bans, are constitutional under the Second Amendment. As of 2026, the Supreme Court faces a surge of cases challenging gun control laws, a direct result of the Bruin decision. The justices are considering whether to hear a challenge to Cook County, Illinois' assault weapon ban, which targets AR-15 style rifles. Previous challenges like Maryland's ban were declined, but several justices signaled the issue can't be avoided much longer. The court is also reviewing cases on high-capacity magazine bans, with petitions from states like California and Washington under serious consideration. 14 states have such restrictions, making a Supreme Court ruling highly consequential. The docket also includes challenges to federal laws barring felons from gun ownership and other gun-related issues. The court's decisions in these cases will reshape gun rights and regulations for years to come. Supporters of assault weapon bans argue these firearms are military-style, designed for rapid fire and high-capacity magazines, making them especially dangerous in civilian hands. They believe that such weapons, originally intended for the battlefield, have no place in everyday society, and that their presence increases the risk of mass casualties during violent incidents. These advocates often point to the devastating impact of mass shootings, where assault-style weapons have been used to inflict significant harm in a matter of minutes. They argue that restricting access to these firearms could help prevent future tragedies and save lives. Supporters also reference a historical tradition of regulating especially dangerous weapons, such as machine guns and sawed-off shotguns, which have been subject to strict controls for decades. They see modern bans as a continuation of these efforts to keep the most lethal weapons out of general circulation. For them, banning assault weapons is not a new idea, but rather a modern extension of long-standing principles aimed at protecting public safety and reducing the potential for mass harm. On the other hand, opponents of these bans argue that the firearms in question are semi-automatic, not fully automatic machine guns, and function similarly to many other common rifles used for hunting, sport shooting, and self-defense. They emphasize that millions of Americans use these rifles lawfully every year, for activities ranging from target practice to home protection, and that banning them would unfairly punish responsible gun owners. Opponents also contend that many proposed bans focus on cosmetic features, such as pistol grips or adjustable stocks, rather than the actual function of the firearm, making the laws arbitrary and ineffective at addressing real crime. They argue that such restrictions violate the core protections of the Second Amendment, which they interpret as guaranteeing the right to own commonly used firearms for lawful purposes. Gun rights advocates often cite the Supreme Court's common use, idristamestar usdani, intramitentros, tidan yidristartans, which suggests that firearms widely owned by law-abiding citizens cannot be banned under the Constitution. They maintain that because these rifles are among the most popular in the country, any attempt to prohibit them would be unconstitutional and ineffective at reducing crime. Instead, they insist that lawmakers should focus on addressing criminal misuse of firearms, enforcing existing laws, and targeting those who break them, rather than imposing new restrictions on law-abiding citizens. Ultimately, the debate centers on whether the potential lethality of these weapons justifies a ban, or if such laws go too far and infringe on fundamental constitutional rights. As lawmakers, courts, and citizens continue to grapple with these questions, the issue remains one of the most contentious and passionately debated topics in American society. The 2020 months, Kwan of the Bansan, Abdan Stewart, Mine and Mine. Bruin decision revolutionized how courts review gun laws. Previously, courts balanced public safety against gun rights, often upholding regulations. Bruin rejected this, requiring that any gun law must be consistent with historical tradition. Judges now act as historians, searching for 18th or 19th century analogs to modern regulations. This has led to confusion and conflicting rulings, as judges interpret history differently. The result, a wave of challenges to assault weapon bans and other gun laws. Only the Supreme Court can clarify how to apply this new test. Its next ruling will set the standard for evaluating modern gun regulations through a historical lens. Lower courts have applied the Bruin test to assault weapon bans with mixed results. In Washington state, a judge upheld the ban, citing a tradition of regulating dangerous weapons. Gun rights groups are appealing, and federal challenges are on hold pending higher court decisions. The Washington Supreme Court has also upheld a ban on high-capacity magazines. In contrast, a federal appeals court upheld Connecticut's ban, reasoning these firearms are not in common use for self-defense. Other courts have found the opposite, citing the AR-15's popularity as evidence of protection. This split among courts increases the likelihood of Supreme Court intervention. Until then, the legality of assault weapon bans varies widely by state and court. The Supreme Court could take several paths on assault weapon bans. It might strike down all such bans, ruling that popular rifles like the AR-15 are protected by the Second Amendment. Alternatively, the court could issue a narrower decision, striking down a specific law, but allowing for more tailored regulations. The justices could also uphold a ban, finding these firearms are dangerous and unusual and not protected. Or the court could decline to hear the cases, leaving a patchwork of conflicting lower court rulings in place. Each outcome would have sweeping consequences for gun laws nationwide. The nation awaits the court's next move. As 2026 unfolds, all eyes are on the Supreme Court's docket. If the court agrees to hear a case, both sides will submit briefs and present arguments, drawing national attention. The ruling, expected by June, will determine the fate of existing bans and set the legal standard for future gun laws. Whether broad or narrow, the decision will shape the next chapter of America's gun debate. The surge in litigation after Bruen has forced the issue to the forefront. The Supreme Court now has the chance to provide clarity and a national standard. Its decision will leave a lasting mark on American law and society.